For today's story, we are covering a recent decision from a federal court in Texas, which deals with the ability of a male student who had been investigated for sexual misconduct by his school and then found to have not done the thing to now sue the school. And as part of that, he'd like to depose the girl who made the accusations against him. The girl who made the accusations against him is not here for it and has moved to quash the subpoena for her testimony. So in today's decision, the Northern District of Texas has to consider the motion to quash and whether or not this male student who was investigated for misconduct as part of the investigation or part of the lawsuit, rather, can sue or at least depose, rather, the woman who made the allegations in the first place. So let's go ahead and discuss this. On August the 3rd of 2022, the non-party to this litigation, Jane Roe, filed a motion to quash the subpoena to testify. That's what you do when you get a subpoena and you'd like to not subpoena. What you do is you file a motion to quash, and then you state your legal grounds for why you don't want to respond to the subpoena. So Jane Roe had made reports of sexual assault by John Doe, who's filing this lawsuit, which prompted the university, Texas Christian University, to do a Title IX disciplinary proceeding against him, which gave rise to the suit. In addition to compelling production of documents, Doe subpoenaed commands Roe to appear for deposition. So he wants to get documentation from the school and from Roe, but also wants her to appear for deposition. In the motion to quash, Roe objected to the deposition on the grounds that any testimony she could provide lacked relevancy to the claims, and that requiring her to sit for a deposition in which she will face questions about the underlying Title IX proceedings and sexual assault imposes an undue burden that justifies quashing the subpoena. But you're the one who started this entire party, so no. Having weighed Doe's need for Roe's testimony and her testimony's potential relevance with hardship a deposition might impose, the court upheld the subpoena, but did so with modifications. So that's one of the things they can do, right? They can quash the subpoena completely, or they can modify it in order to adjust for these various rules. So, but there was more. In the intervening 2 weeks before the court's first order and the motion to reconsider, Roe obtained a second opinion from a treating professional that indicates that Roe having to sit for the deposition could be a trauma trigger, could cause her distress, could negatively impact her mental health, and may cause her progress in counseling to stall and fall behind. So she is a mental health professional who says her being deposed as to her part in this whole foray might cause some problems for her. But John Doe wants to sue the university, and she's the one responsible for making the complaints. So, does he have a right to confront his accuser, at least in part? Let's learn more. In support of the motion, Jane Roe relies on a declaration from her medical professional, who is a social worker, who's been providing therapeutic services once a week since August the 1st of 2022, which isn't that long, incidentally, which indicates that subjecting Roe to deposition may cause her trauma trigger, extreme distress, to be detrimental to mental health, and could cause her process to stall. Jane Roe also argues that John Doe's need for her deposition is reduced because she's agreed to comply with John Doe's pared down document requests, and John Doe has also obtained a release for her school records, which are protected by federal law. And so he's obtained release for all records that would otherwise be protected by federal law. For that will permit him access to some relevant information from the university. So she's like, but I've been giving you documents, including documents that otherwise might be protected by law, which incidentally, like subpoenas can beat that. But that's like a default presumption, right? And then subpoenas like to get protected information. Sometimes, right? Sometimes you can get subpoenas for protected information. Yeah. When considering Jane Roe's initial motion to quash, the court weighed John Doe's need for Jane Roe's testimony with the burden it might obtain that it could impose upon her, according to her first professional. So she's had two mental health professionals say this would be really, really tough She doesn't want to be deposed. There, the court found that crafting parameters for the deposition rather than quashing it was an appropriate remedy. So the court said, okay, there's some concern here, but we can deal with that by some way limiting the deposition or modifying it. Fine. The court made this determination despite the doctor's testimony that the deposition, I apologize, I said doctor, but it's Mrs. Garrett. So the Mrs. Garrett is some sort of mental health professional, but not a doctor. So I apologize for calling her doctor. She's not. So the court made the determination despite her first professional, Mrs. Garrett's unequivocal opinion, the deposition would, to a reasonable degree of professional certainty, cause significant harm and trauma. She'd like to not be cross-examined on this very much. The court continues to note that the fact that Jane Roe has voluntarily released information via this authorization which relates to her school records, and also agreed to comply with document requests she was otherwise obligated to produce because of the subpoena, is not enough to change the court's assessment. So yes, you gave over some documentation. Incidentally, we might have been able to get those documentations anyway, and we appreciate the documentation and all, but he has the right to ask you questions under oath. The court notes that the permitting Jane Roe's deposition to proceed might impose some degree of hardship, given the sensitive nature of the dispute, but that's kind of part and parcel of it. The burden that necessarily comes with being deposed about allegations of prurient assault is not lost on the court, but the court does not find the burden so unreasonable and oppressive it outweighs John Doe's need to obtain relevant information from Jane Roe regarding the underlying allegations. So yeah. So the court has thus imposed the following modified deposition framework. There should be a single deposition that occurs as a neutral site, which, fine. The deposition shall be limited to 4 hours. That's pretty short for a deposition. No more than 2 attorneys may be present by either party. Fine. Jane Roe shall be entitled to have one party present aside from counsel, so her therapist can attend or whatever. And John Doe may not seek any information from Jane Roe regarding prior prurient history, which, fair enough. Not as it doesn't concern him, that's fine, it's immaterial, with anyone other than him, in order to refrain from seeking material for the purpose of embarrassment, harassment, or improper means. Yeah, I imagine there's going to be further fighting over this because she's going to say that everything is embarrassing, harassing, or improper. So this is probably not the end of this story, and the court will probably modify the order further, but we're going to give this a try. Thus, that brings us to the end of this discussion for the moment of John Doe versus Texas Christian University. John Doe was accused by Jane Roe of sexual assault. Now, among whatever other liabilities that would incur, that might be a violation of Title IX under the relevant case law. So the university did some sort of investigation. And now he wants to sue over that. And in order to do that, he needs to get material. Whether or not he can succeed or not is a whole nother set of problems, but we made it past the motion to dismiss stage, apparently. So we're in this discovery. He wants discovery from the university and also from his accuser. He wants to see documents, emails, phone calls, whatever, and he wants to depose people, including her, which is pretty reasonable. She's like, I can't be deposed. I can't be asked questions under oath. It would cause me trauma to have to relive it. And we're all like, dude, man, you accused him, and as a result, he was investigated and had his life turned upside down, and now you don't want to be cross-examined. Well, the court is more merciful than I would have been in this situation, which goes to show the temperament of different judges. It's like, you buy a ticket, you're going to take a ride. He has a right to due process, amazingly. But the court has ordered some limited remedies, which I imagine is not going to go well, and we'll be back in court arguing about further compliance issues and stuff like that. So this probably will go on for a while, but at least for the moment brings us to the end of discussion of this story.